Well, it's been weeks since the announcement that sacked Twitter employees in Ghana had finally received compensation from Elon Musk. Now, the workforce faced layoffs in November 2022, just after Elon Musk acquired the company for 44 billion US dollars. According to Ghana's employment law, employees are entitled to redundancy payments and should receive a 3-month notice before being laid off. The workers had contemplated legal action against X due to the company's failure to provide them with redundancy payments. Well, join us with some insight into what went into the negotiations and what lessons there are for employees is Carla Olympio, a corporate lawyer, also managing partner for Agency 77. Thanks for joining us this afternoon and agreeing to speak with us, Carla. I know you cannot give so much out about the negotiations, but what did it take to seal the settlement?
In this case, without speaking to any specific details of the process, obviously we would like to respect the confidentiality of our clients and of the process. What it was a negotiation. I have seen some news reports, perhaps not in Ghana, but internationally, talking about a court case. It was not a court case because what we were seeking to enforce were the provisions under our Labor Act, which require that when there's a redundancy, prior to the actual redundancy, there's a process in which a company is meant to file a notice with the Chief Labor Officer of Ghana, who's an officer under the Labor Department. The Labor Department is under the Ministry of Employment. So you're meant to file a notice with them, then engage in a negotiation process with the potentially affected employees, come to an agreement, and then do the layoffs. So this is what we were, kind of retroactively seeking to do. And that's what we did for the duration of the period, basically negotiating for an appropriate settlement.
And how does this process compare with other Twitter staff in other countries fighting for their packages?
Every jurisdiction is different, right? So there are some jurisdictions that have slightly similar laws to ours. Now, I'm not an expert on other jurisdictions, but obviously in doing our research, we noticed that there were some. So for example, if you look at the United States obviously has a sort of federal system, state by state. So in California, there was kind of a similar system where they have to, give some kind of notice and engage in a negotiation, right? That's what they're meant to do there. And then I believe in England as well, there's a similar process where if it's over a certain amount in a planned mass redundancy, a certain number of people, there's a similar process. But, obviously it varies from country to country, contract to contract. So, it really varies from jurisdiction to jurisdiction. And it's important to say that Ghana actually has quite a strong regulatory system in this aspect. There are certain places where employees are less protected in the case of a redundancy than Ghana. So, should companies follow the process as laid down in the Labor Act, it's actually quite labor friendly.
Well, I know you don't want to give out so much. Did they receive a fair compensation? Are the clients happy about the outcome?
What I can say is that, look, it took a long time, but eventually it's all been concluded. There's nothing outstanding. And, my clients, or shall I say my former clients now, I think that they're very happy to put this behind them and look to the future. So that is what I will say. And, we are also pleased to have represented them in this matter and that, after a long period of time, it's been wrapped up.
So is there a gap in our labor laws when it comes to redundancies? And what should be the policy direction to protect local workers in similar situations?
What I would say about Section 65 specifically and regarding redundancy, which is like I said before, is that actually it's a fairly well thought out provision, in the sense that, it provides for a notice to the government. So it's kind of a process that is nominally overseen by the government, but the government doesn't actually interfere in the process. Which is also a good thing because obviously private organizations and private individuals are allowed to contract in and out of, employment relationships. So the government doesn't actually interfere. What the government seeks to do under the auspices of that act is just to ensure that there's a fair negotiation, especially where, there's redundancies and a lot of people might potentially be affected. So I would say in terms of the regulation itself is quite well thought out. I think the only thing, the improvements, which are a lot of, labor experts and lawyers and potentially affected employees, might look for from our legislature, is that it doesn't actually come with enforcement. So unfortunately, under that particular provision, there is no there's no provision where the Labor Department or the Chief Labor Officer can say, okay, a company that is defaulting in its responsibilities under this section, we can fine you. We can fine you so and so amount, right? So unfortunately, even though the provisions are very clear and they're quite well thought out, there is no enforcement attached to it. And I think if there was, it would give it more teeth. So, right now, employees can, go under it and say, look, this needs to be enforced. But, if an employer does not do so, ultimately, perhaps what you could do is then file a complaint with the National Labor Commission, or you could take it to court, if a company is very recalcitrant, because the Labor Department under that particular section does not have enforcement power. So I think enforcement powers, for example, setting out a regime of fines would be a good thing.
What should employees who wish to work remotely with foreign companies look out for in their contracts, or what should they demand from the employers?
So I think that there's a lot of things. I think there's two things. The foreign companies setting up here, we already have, quite a large number of multinationals in Ghana and have had for a long time. And I have to say that most of them do respect, the laws of Ghana, the labor laws and stuff. They have redundancies. There have been various redundancies, various companies. I mean, even if you look at a company like Vodafone or Tullow, they've had redundancy exercises. Obviously, they have Ghana registered entities, but the parent companies are not Ghanaian, right? So I think in and of itself, there are many foreign companies that, have very strict, governance and compliance rules, and they ensure that they respect the rules of the country. I think that, with any employment, you need to look at, in fact, with any contract, but I'm speaking of employment, very often people are entering into employment relationships or other relationships, they're looking at the clauses that govern things like what they're going to get, the current situation. They are not so careful about looking at things like when there's a termination, what will you get when there's a termination? And I think, therefore, just narrowing it to this kind of situation, because obviously it's a very broad question, if we narrow it to this kind of situation, I would think that you need to look at those things, who exactly is your employer? Sometimes you come across situations where there's a company that's employing you, but then you end up signing the contract. There's another entity's name on the contract. So you need to look at that. You need to question it. And, and ideally, obviously, I know not everybody can afford to get a lawyer or some kind of labor expert to look at it. But if you can get somebody to look at it, that might be a good thing. If there are too many red flags, sometimes, people need jobs and they're very eager. They can see the red flags, but they go ahead and sign. But sometimes the consequences can be very serious. So I would say, look at things like that. Look at things like, the termination clause. Look at what you get in the case of a termination. Look at the notice period, things like that, the extra benefits. And I think, you're talking about companies, multinational companies, with the increase in things like remote work. Now, there's a lot more people who are into things like, IT, etc. There's more, subsequent to the pandemic, obviously virtual work has become more popular. Even sometimes in the situation, I know there's been a couple of litigations on the continent so far regarding organizations like Uber, right? So I think there's one in Kenya, there's been one in South Africa. And sometimes, the ability to enforce or not your rights is a problem because sometimes they don't have an entity in the country, right? So you have to think about, what entity you're actually signing with. Will you be able to enforce any rules against them if they do not do the right thing by you? And also importantly, just slightly more broadly again, just to ensure that you are complying with other aspects of our laws, like tax laws, for example. Some people think, because it's a remote job, they don't need to pay taxes, but they do. So there are some companies that do things like they have outsourcing companies that are the ones that they sign the arrangement with. So I think look at those things,
All right.
and also look at the track record of the company if you can. Look at the credibility of the company and the track record. Take it into account. Like I said, jobs are important, a salary is important, but if there are a lot of red flags, perhaps reconsider signing an
All right.
agreement with that entity.
All right, thank you so much. Carlo Olympio, the corporate lawyer, also lawyer for ex-Twitter staff who we now know have finally got their payout after they were laid off in 2022 November. I appreciate your time with us.